So, the 2024 legislative session saw at least 45 states introducing AI bills and 31 states adopting resolutions or enacting legislation on AI. This is according to the National Conference of State Legislatures. So it's safe to say that in 2025, it's going to be a lot of regulatory updates on AI. So let's dig in. Please join me in welcoming our next panel.
Good morning, everyone. Good morning. My name is Travis LeBlanc. I co-chair Cooley's Global Cyber Data Privacy Practice and am delighted to be here with all of you this morning to kick off this year's Fall Forum with a panel on regulatory developments in artificial intelligence. As I know everyone already appreciates, AI is one of the hottest, if not the hottest, topics in the corporate world. But what may or may not come to you as welcome news is that it is also amongst the hottest regulatory topics in the world. There are national and international initiatives, including safety institutes, multilateral summits, and flagship policy measures, such as President Biden's AI executive order and Europe's AI Act. Just about every government, regulatory agency, and even the courts are all thinking about the best approach to AI, from the use of AI to regulation, to governance, to enforcement. They're contemplating not just public policy issues like consumer protection and competition and differential treatment, but also how AI can and will impact businesses, decision-making, and our everyday lives. And while some applications of AI raise new legal issues that will require new laws, such as algorithmic training, many uses are already governed by existing legal and governance frameworks that continue to apply to AI as they do all technologies. Our panel this morning will explore the existing regulatory landscape for AI, anticipated regulatory developments, and key considerations that any company developing or deploying AI should keep in mind. We're excited to have a group of distinguished panelists here who can speak to these topics from a diversity of perspectives, including the European, the United States perspective, and of course, California. I'd like to have each of the panelists briefly introduce themselves, and I'll start with Senator Wiener on the end and work our way down this end.
Great. Good morning, everyone. I'm Scott Wiener. I have the honor of representing San Francisco and northern San Mateo County in the California State Senate, and before that served on the San Francisco Board of Supervisors. I think I'm here today because I, this year, authored Senate Bill 1047 around frontier model AI safety.
Good morning, everyone. I'm really happy to be here today. My name is Monique Winkler. I'm the director of the SEC's San Francisco Regional Office. I've been with the SEC for almost 17 years. I started back as an attorney in the enforcement division. I became the regional director in 2022, and prior to that, I was the head of the enforcement program in San Francisco. And maybe I'll just quickly give my disclaimer because there's not really a good time to do that. The views I express today are made in my capacity as the regional director of the SEC's San Francisco Regional Office, but do not necessarily reflect the views of the commission, the commissioners, or the SEC staff.
Hi, everyone. My name is Irene Liu, and I am an AI advisor for the California Senate with the privilege of working with senators like Senator Wiener. And I also advise Berkeley Law's AI Institute, Women Defining AI as well. I was a former general counsel and also a trial attorney at the U.S. Department of Justice in the Antitrust Division, as well as the FTC. And I am here speaking in my personal capacity.
Good morning. I'm Gerard de Graaf. I'm the Senior Envoy for Digital Policies to the United States, and I'm head of the EU office here in San Francisco. Before I was in DG Connect, which is the digital department in the European Commission working on regulation, particularly on the Digital Services Act and the Digital Markets Act, but also on AI, and it's a pleasure to be here, and I have no disclaimer.
And lastly, I'm Travis LeBlanc from Cooley. In a previous life, I worked in the California Attorney General's office for then Attorney General Kamala Harris, also worked at the FCC, DOJ, and Harad, I was an arbitrator under the EU-US Privacy Shield agreement back in the day. I'm here to moderate the conversation, and let's get started. Senator Wiener, I'd like to direct the first question to you. Many people in the room are already aware that California has historically been a trailblazer in just about all tech policy issues. And that has continued to be the case in the United States with AI. You have authored legislation that you mentioned on AI, particularly the Safe and Secure Innovation for Frontier Artificial Intelligence Models Act, also known as SB 1047, which made its way through the California legislature, but unfortunately, Governor Newsom did not sign it, although he signed a dozen other AI bills. To get us started, how do you see California's role in regulating AI? And can you tell us a little bit about SB 1047, including why you authored the bill and what it did?
Sure. So California has a huge role to play in terms of both tech innovation and fostering that innovation, and also making sure that we're being responsible in how tech innovation happens, and that folks are keeping in mind the public health and safety and the needs of society at the same time that they are making amazing things. And we play that role for two reasons. First, because this is the fifth largest economy in the world. We're going to be we thought we were going to be the fourth, but then Germany sort of stepped it up a little bit. And and because this is the beating heart of tech innovation globally, particularly the Bay Area, and with AI, San Francisco. So we have that huge role to play, and we really have an impact. But on top of that, you know, at an ideal level, we would love for a lot of this work to really be happening robustly at the federal level. But unfortunately, the federal government, or Congress in particular, Congress is, despite the narrative that Congress does nothing, Congress has actually in recent years done a lot of really, really good things around infrastructure, semiconductors, around climate action, and so forth. Congress has really deeply struggled for many years to regulate the tech sector. With the exception of banning TikTok, the last major tech regulation law was in the 1990s. And Congress could not even get it together to pass a basic election-related deepfakes law in advance of this election. So in the absence of congressional action, and particularly now with Donald Trump being elected president, and one of his planks was to rescind the Biden AI safety executive order. We have members of the House of Representatives who have pledged to defund NIST. And so we are at risk of seeing the relatively low level of federal action that had happened through the White House without force of law, even that being downgraded. And so California, more than ever, has not just a role but a responsibility to act just like we did when we passed a data privacy law in 2018. Congress has never passed data privacy law, or when we passed a net neutrality law that I authored in 2018, and so on and so forth. And SB 1047 in that spirit would have required the largest labs developing the largest frontier models to perform basic safety testing before they release the model, which they have all pledged to do. We wanted to put that into law. And it also requires them to be able to shut down the model as long as it's still in their possession. So it was a pretty basic law, but it caused a whole mega kerfuffle, which is great. It advanced the conversation, and I'm already in further conversation with opponents. And the governor did veto it, but made clear that he wants to continue to work on this, so we'll continue to do so.
Thank you for that background, Senator. Now, California is not the only government that has been active on regulating AI in the past year. Let's hop across the Atlantic to Europe, which has been quite busy enacting the EU AI Act. Gerard, can you provide some background on the EU AI Act, including a brief status update and how it fits within the EU's broader approach to AI regulation?
Yes, I can. I think the key word is safety here. When you walk into a shop and you buy something, food product, you believe it's safe. You step into an airplane, you believe it's safe. If you buy a car seat for your kid, you believe it's safe because it's regulated. And AI has tremendous potential. It's a fantastic technology, but there are safety issues. If you look at some of the automated decision-making systems, many of them are like black boxes or are like biased in a way. If you look at these powerful models, and the industry itself is the first to admit they also represent risk. Well, the role of government is to address those risks, to make sure that we can live in a society where we don't have to think all the time, like, can I really use this? Is it safe? Is it not going to harm me? And so the starting point for the EU regulation is safety, trustworthiness. And actually, we've modeled it on the tradition of product safety. We have a long tradition in the European Union, but also in this country, that we regulate products that pose certain risks to safety. We do so by setting out essential requirements, and then through standardization, the industry sets that kind of standard that reflects those essential requirements. So this is what the European Union has done. And what surprises us a little bit is that it's become so political. These issues in the European Union, maybe because we're a little bit more boring in the European Union, are not political. They're bipartisan, because everybody believes that AI should be safe. And if you look at surveys around the world, including in this country, in the European Union, about half of the people are apprehensive about AI. They believe that they can't fully trust AI. And in this country, also, even more than in Europe, people are concerned about AI. And that's therefore also in the interest of the market to make sure that when people are confronted with AI, they know they can trust it. That also, if you're in the industry and you're providing an AI application or an AI model, you're not going to get into a situation where others who are not following the high standard are basically spoiling it or tarnishing the reputation for the whole industry. So it's a product safety approach. We focus on risk. We have a called risk pyramid. Some of the AI applications we don't want in the European Union. Really AI used for mass surveillance. That's not what we like in the European Union. We want people to have a degree of privacy. We have high-risk applications. This is where AI is used in areas where decisions have a material impact on people, like in financial services, like in medical, like for recruitment purposes. And then we have the low risk or minimal risk where transparency is enough. In general, when people say, look, the European Union, you're regulating AI, we're regulating no more than 10 or 15% of AI. 85% we have no concerns about. So we regulate where we believe AI poses certain risks, and then we impose certain obligations on the providers of these applications or the ones that are developing these models to mitigate those risks. And that's what we've done for 40, 50 years in the area of products, and we're now doing it in the area of AI, and including in the area where AI is embedded in products. So for us, it's a logical thing to do. In terms of the state of play, it's in force, but not in application. So since the 1st of August, so a few months ago, it's the law in the European Union, but it has a staged implementation. The first stage is after 6 months, so in February of next year, when we will no longer accept the so-called prohibited AI uses, so like mass surveillance or emotional use of AI to have people take decisions that are against their own interest. Then 12 months, and this is very relevant, we start to regulate these powerful models, because in the European Union we have the EU AI Act covers what Senator Wiener has been trying to cover in his SB 1047, which is these powerful frontier models, but we also cover in the same act the applications. And so for the powerful models, it's 1 year after entry into force, so the beginning of August next year, and then 2 years later, we start applying it to the system, so August in 2026. And then 3 years later, we start applying it to AI embedded in products, so that will be August in 2027. So that's the kind of state of play.
Yeah. So we're right now in California. A lot of people here work in California companies. We have a lot of people online, and they're hearing about the EU AI Act. If you're just operating in California, should you have a concern about how the EU AI Act may regulate you? Who does it apply to?
Well, it applies to those providing systems that will be used in the European Union. So if your market is like California, you never ever think about like even going to kind of to abroad, going to the European Union. No, there's nothing to worry about. But technology, and particularly AI, is global. I mean, the companies that are here in Silicon Valley aren't thinking, okay, as long as I'm successful in California, it's all right. These companies here are thinking global. They're looking at the European Union market. The European Union market is a big market, 450 million users. I mean, US companies that are established here are tremendously successful in the European Union. So I don't think there are that many companies that would say, okay, well, we'll just leave the European Union as it is. We're not going to kind of even kind of provide services there or make our technology available. So I think the EU AI Act is relevant to a lot of kind of companies here, and it's also relevant because like other countries around the world are taking inspiration from the EU AI Act. I mean, we're working closely with California to see to what extent we can converge or at least to align as much as possible. So it is going to be, I mean, the idea that somehow AI will not be regulated in this country is a very strange idea, actually. And so, as it's going to be regulated, of course, what the EU has done will serve as a source of inspiration, both for good and bad, but hopefully more for good.
Yeah. Now, Monique, Senator Wiener took a swipe at Congress not too long ago on their relative inactivity. I hesitate to think that...
Not a swipe, just an observation.
Observation. I hesitate to think that 2026 federal election will come around and maybe you're thinking ahead. But he is right that Congress has not done much when it comes to tech policy and virtually nothing on AI. Some people might see the CHIPS Act as a way to do it. But federal regulatory agencies have been a little more active in the AI space, whether it was the Federal Trade Commission, the Consumer Financial Protection Bureau, the EEOC, the FCC, and the SEC has also been active in the AI space. Can you tell us a bit about how the SEC has approached regulation and enforcement activity around AI?
Sure. So in the absence of particular laws, we're using our traditional tools and theories in enforcement. I hesitated to say it here, but it's actually not the particular technology that drives what the SEC does in this space. It's the SEC's mission. We're a mission-driven organization. The mission is to protect investors, which I think is particularly important here, maintain fair, orderly, and efficient markets, and facilitate capital formation. So I think it's very important to be mindful that the same statutory provisions and standards that the Commission has applied for years, dealing with false statements, misrepresentations, and deception by issuers and investment professionals, also apply in the AI space. And that's including violations of the Exchange Act, the Securities Act, the Advisors Act, all of which have been around, I think, probably longer than any of us have been around. So for this audience, the Exchange Act and the Securities Act are the most relevant. Sort of taking a step back, I mean, we all know AI has, maybe already has done, sort of changed society at large. It has the potential to do that. So in the big picture, as we see AI develop, we see parties, companies, whether they're public companies, private companies, seeking to capitalize on investor interest in AI by promoting their adoption or their utilization of it. This includes, like I said, private and public companies. Such companies are potentially utilizing AI to enhance their business's productivity, offer new services to customers. At the SEC, we are looking at what disclosures these private and public companies are, or perhaps are not, but should be making to investors related to their use of AI or AI's impact on their business. In other words, we're concerned with disclosure failures. As one example, we're concerned with misleading statements about AI capabilities, generally overselling AI products or services to attract investment without the technology to back it up. Things like this fall into a category that we could call AI washing, essentially committing an old school fraud using new school buzzwords like artificial intelligence and automation. As another example, though, with all the positives that stem from the continued development and adoption of AI across various sectors, there have been corresponding risks and challenges created for certain companies. Among other things, these risks could be competitive, operational, or legal in nature. If they're material, though, they need to be disclosed to investors to help make sure that investors have all the information they need to make informed decisions about whether to purchase or sell a security. So drilling down even more on that example, the deployment of new AI tools in certain industries could make prior business models obsolete. They could add significant competitive pressures to existing players in the industry. Under those circumstances, it may be necessary for the existing players to disclose facts surrounding those competitive risks posed by AI to the company and the impact of the competition on their financial products. So importantly, to be most useful to investors, such disclosures need to be specific to the company at issue and particular to the operations and risk of that company, not boilerplate. So those are two examples of what the SEC is looking at and doing in this space, sort of how we're policing in the absence of any specific statutes.
Yeah, and I think the SEC also has an AI rulemaking that may or may not go anywhere now after the election. But a lot of what you described, Monique, is actually similar across all the federal agencies that are looking at the competition angle from their vantage point, or the consumer protection, investor protection angle that you have there. So it actually, the AI washing, for example, you could see play itself out at the Federal Trade Commission as well. Now that we've heard a little bit about the European, the Californian, and the federal approaches, Irene, you know, we should look to you as an advisor to governments and companies for some general takeaways. What key trends are you seeing across the AI regulatory landscape more generally?
I mean, you've heard many comments and observations about the federal government, especially with the elections. You will continue to see not much being done around tech policy and AI, and especially under the Trump administration, we anticipate that there will be a de-emphasis on AI regulations even further than before. And we anticipate that potentially even President Biden's EO may be repealed or reversed. And so that's at the federal level. And at the state level, what we've seen in the past, even this past year alone, is that we've seen almost close to 700 AI bills being passed across 45 different states. This is a statistic that was tracked by the Business Software Alliance, the BSA, and there continues to be a lot of activity at the state level, given that at the federal level there has been limited activity. The trends around the AI bills that are happening, especially this year, has been around deepfakes, restrictions of digital replicas, government's use of AI, as well as high-risk AI. So we expect that there will be a continual trend and focus on these particular topics, but we anticipate that there will continue to be efforts around safety, high-risk AI, as well as other workers' protections, bias, privacy, security, and other areas of AI as well. But what I'm seeing that's really interesting is that with AI policy in particular, compared to other technologies in the past, there's a lot of efforts by government as well as companies to try to understand each other. Neither parties want to stifle innovation, and because of that, the government is proactively working in many ways with companies to try to understand the technical feasibility of the types of bills that they're proposing and trying to understand the technology itself. Companies as well are investing a lot in advocacy so that they can try to help governments understand the technology as well so that it's not stifling their innovation. So you see a lot of collaboration between the two groups, and what you'll continue to see is that continued collaboration, and if anything, more advocacy and more investment in advocacy teams and lobbying teams. And we've seen it in certain bills, like Senator Wiener's bill, And so that trend will continue, and you'll hear louder voices, particularly from big tech, that are asking for particular regulations, particularly at the output level versus the input level, or regulating at the application level versus the model level. And so there will be lots of different voices, and there will be a lot more time, money, and investment poured in this space, and it will continue next year, and California will continue to play a leading role in this space.
Yeah. I'm slightly more optimistic, Irene, about the possibility that a Trump administration will actually grapple with AI. I think what we see when it comes to AI regulation is it's not really a partisan issue. It's not like there's a Republican perspective on AI regulation versus a Democratic perspective that's staunch. We saw, the Senate coming together almost overwhelmingly, U.S. Senate, last year to host workshops on AI. That's not a lot of activity there, but there's a lot of competition issues that come up because of the European regulation of U.S. companies not having a regulatory framework that's there. I almost, I can't tell you what it's going to look like, but the idea that we do nothing, even Gerard here says, the idea that the United States does nothing, it seems a little bit odd. I'm not optimistic for a massive amount. I'm not optimistic that President Biden's executive order is going to go unchallenged on AI, but I'd like to think that there are business forces that are at play and compelling some activity there. We'll see how it all plays itself out. One thing I do know, though, having heard all of the conversation, is there is a huge, massive debate over whether to focus regulation at the output level or at the model level. And so I want to actually go back to you, Senator Wiener, because this was probably the most controversial aspect of your legislation, and one that I think would be good for the audience to hear a little bit more about. In your opinion, what are the pros and cons of regulating AI at the model level versus deployment or application level?
Yeah, this is, I'm going to be honest with you, it's a very frustrating quote unquote debate, because the answer is clearly both. And I think there were some in the opposition to SB 1047 who I thought to me, it was a very flippant way, were dismissing any idea of regulating anything at the model level. They would refer to it as quote unquote regulating math. Okay, sure, but it's math that has incredible power, and the power is at the model level. The model level is what allows those applications to happen, whether it's someone using an AI model to make it much easier to build a chemical weapon, or algorithmic discrimination, or someone making it easier for someone to melt down the banking system or shut down the electric grid. And so the idea that we would just focus at the application level, in other words, how people are using the model, and not focus on the safety and the appropriateness of the model itself, to me makes no sense whatsoever. If someone is going to shut down the electric grid, that is a crime, and that person should go to jail and be held responsible, whether they do it using an AI model or whether they do it some other way. That's a crime, and we should, of course, hold them accountable. Wouldn't it be even better if we made it harder for them to use the model to shut down the electric grid with all of the massive harm that does, or to build a chemical weapon, right? Why is it that we would only deal with it after the fact? You did this bad thing and used an AI model, so we're going to, of course, punish you for doing that. That's the application level. Of course we should do that. But isn't it better not to have caused that massive harm to begin with? And that's why on SB 1047, despite some of the opposition claims, we were not in any way asking model developers to guarantee that their model could cause no harm. or to ensure or certify that it can't cause harm, or to eliminate risk entirely. Life is about risk. There's always going to be risk. All we were asking is, hey, can you please do a basic safety evaluation of your model to determine if there is a risk of catastrophic harm? And if you do identify that risk, can you please take reasonable steps, not to eliminate the risk, but to reduce the risk? And hey, while you're at it, can you make sure that you're able to shut down the model if it starts doing something problematic? And so these are not crazy things. I agree that you can go too far and say the model developer has to certify that there is no risk of anything bad ever happening. That's not the real world, and that's not what we should be asking. But asking if there are basic mitigations that you can evaluate and take, I think is perfectly reasonable. So the answer is both and.
Yeah. Gerard, you mentioned earlier that the EU regulates both. I think that's what you said. How does the EU approach compare to SB 1047? And how do you see harmonization if SB 1047 becomes law? How does a company that's looking to operate globally, that is working in both jurisdictions, ensure that they can have consistent practices that work across the globe?
Yeah. I mean, for the reasons that Senator Wiener has outlined, that's the reason why the European Union kind of captures both the model level and the application level also, because for the applications often you use a model that has been developed, so the two cannot be kind of separated, at least not easily. Maybe just say a few words about the approach that the European Union takes, and maybe that's slightly different from the approach taken in the United States. And part has to do with just our traditions, our legal traditions, our history. We are a little bit more on the precautionary side. We think about problems before they occur. Maybe in the US it's a bit more like laissez-faire, and then if something happens, you get a reaction, sometimes a knee-jerk reaction. There's much more emphasis on liability in the US. We look a bit more like, well, if we put these obligations in place, you actually you cannot be held liable. So this is your protection against being held liable. I think another difference, and it's a relevant issue in the US. If the EU doesn't regulate, the member states will and have. One of the reasons why in Europe it's difficult to grow big digital companies is because we have a fragmented landscape. Many member states have regulated in different ways. So if you're a company like in Germany, you want to expand to the rest of the European Union, you will have to adjust your business model to rules that are different in France and different in Italy and different in Spain. And that just slows you down. It increases your costs. I often say if you're a startup, you want to expand, the first person you need to hire, which is what you like to hear, Travis, is a lawyer. Is not a product engineer or a software developer or a business manager. No, it's a lawyer. So to put a framework in place, one set of rules for the whole of the European Union is in many ways deregulatory, which is people say, well, what are you saying? You regulate and it's deregulatory. Yes, because we remove a lot of national laws from the books because of the primacy of European Union law. I think the other difference a bit is within the law, we put flexibility. We can adjust. There's been some discussion about because we put the threshold for the coverage of these very powerful models lower than the US in the executive order and lower than in SB 1047. We put it at 10 to the 25 flops, and in the US it's 1026. So people say, oh, you're going to be inundated by models. You're going to be blown out of the water. Well, let's see. But if that's the case, in the legislation, we have the opportunity to change the criterion, to move it up or down as we think is fit. And so we have within the legislation opportunities to change the legislation. That has been empowerment given to the executive branch, which is the European Commission, which typically you don't have as much in the US. You would have to go back and renegotiate. We don't have to go back and renegotiate. And I think the third maybe difference is we often use the word co-regulation in the European Union. We don't like self-regulation because we have seen, people told me, a lot of industry, oh, let us regulate ourselves. Well, we haven't seen massive success coming, on the contrary, from self-regulation, particularly when the interests aren't aligned, when the business interests aren't aligned with the societal interests. Self-regulation is a recipe for disaster. It's not going to work. Co-regulation, however, can work. So in the AI Act, for example, for the supervision of these very powerful models, we set out some kind of key methods. I mean, do red teaming, do alignment, etc. But how to do this, we're now asking the industry and stakeholders and civil society and academia to come together in a forum, we call that the Code of Practice, and start developing a code of practice that translates, say, the requirements, the obligations in the EU AI Act in practical ways of how to do this. Process has started about a month and a half ago. 1,000 stakeholders are involved, should conclude by April. Then the European Commission likely will say, okay, that's a good, a fair reflection of, say, the provisions in the EU AI Act. Now please implement it. So this is what co-regulation, it's co-regulation with teeth, because if companies don't implement it, or they make they deviate from it, we have the implementation, the enforcement powers to say, okay, but now there shall be consequences, which you don't have with the self-regulation. So there's a number of techniques that we have in the European Union also to stay abreast, to move with where the technology is going. In terms of convergence, I mean, I'm not going to give an estimate about what will happen at the federal government level. I mean, I was posted in Washington, D.C. at the end of the 90s, and I dealt with the safe harbor, the first safe harbor for privacy. And I still remember the senior officials saying, oh, there'll be a privacy law very soon in the United States. And the very soon is now 25 years later, and there's still no privacy law. So I'm a little bit skeptical about what I hear about what will happen in the US Congress, but that's not my responsibility. I mean, we will work with whoever is working on this, because the technology is global. So we work around the world with other jurisdictions that are also looking into how to regulate AI, are asking many of the same questions that the European Union has asked. So the advantage is they can talk to us and say, look, why did you go this direction and not that direction, etc. And now we are gaining some experience. So what are you gaining? What are the lessons for us? And like with California, I mean, we're looking to see to what extent we can converge. Again, there's the different, your own legal traditions. There's, maybe differences of view. But for example, on definitions, we've worked very closely with California, because if you have the very different definitions, I mean, forget about convergence. If you are regulating, your scope is different from the scope in the European Union, because your definition of what is covered is different from in the European Union. We're not going to get very far in terms of convergence. So this is, I testified at the Assembly in Sacramento, and there's a specific bill on the definition. It is the same as in the European Union. We look at the risk assessment framework, also in the bill of Senator Wiener. It is similar, if not the same. So on those issues, we can converge as much as possible. And then wherever there's standardization, standardization is always the magical wand between a jurisdiction that doesn't regulate and a jurisdiction that regulates. At least, you need standards in this area. The US is very active in ISO, in other standardization fora, and the EU as well, on setting standards. Well, that's where we can also rely on the same standards. In our case, maybe because it's a way to demonstrate compliance with the EU AI Act. In the US, because it's the only thing that might be available for the time being. So we're looking to converge, and obviously California is a very important partner for the European Union.
Gerard, you used a word in your comment, supervision. And I think, there's a real concern amongst a lot of the AI industry in the United States about a government agency that is supervising the day-to-day activities. And there is government involvement in SB 1047. It remains to see whether ultimately we need a state or federal government agency that is overseeing AI. Unfortunately, we don't have a lot of time. Oh, you want to? Yeah.
Well, if you have legislation, you need to enforce it. So that's what is supervision. You can't just have legislation and say, okay, industry, you go ahead and we'll trust you. I think industries, we have it with social media, we have it with marketplaces. We have other laws in the European Union. The AI Act isn't the only digital law in the European Union. I mentioned the Digital Service Act, Digital Markets Act. These companies are regulated industries, insofar as the EU is concerned, whether they like it or not, because they're regulated. And if you're a regulator, you want to be sure that the regulation is complied with, and that's why you supervise, and that's why you you follow what the compliance looks like. So this is something maybe to get used to. If you're a social media company, you haven't been regulated for a very long time, it's only regulated, but that's the way life has changed. In the European Union, you're regulated.
If you're in Europe, be prepared to be regulated, says Gerard. We have just time for one last question, and I want to just do a quick round across everyone. From each of your perspectives, what do you expect or hope to see next for AI regulation? And I will start with Gerard and give Senator Wiener the last word.
Well, implementation. I mean, we've regulated, so this is not that there's another wave of regulation coming from the European Union. It needs to be bedded down. So we're now focusing on implementation. That's a collective exercise. I mean, everybody needs to kind of come in and provide input in how the legislation can be most effectively implemented. And that is also like the role that the industry can play. This technology is complicated. It's a complicated area. I mean, also for regulators, very complicated.
Irene.
I would say safety, but I know Senator Wiener is going to touch on that. So the other area that I would love more eyes on is climate. There's such a significant impact and use of energy and water to power these AI systems. And so I would love more eyes and thoughtfulness around policies around climate impact of AI.
The work that the SEC is doing in this space now, whether it's through enforcement or examinations, is really the bread and butter of the work that the SEC does, and I anticipate and hope that that will continue.
I agree on the climate front, and I actually think it's a great opportunity to work with the tech sector to help get these labs out from underneath the heel of PG&E and other monopolies, and give them the ability to generate their own clean energy. PG&E is a monopoly, and these monopolies don't want us generating our own power, and maybe this is an opportunity to break that monopoly. We'll continue to work on safety, and I think algorithmic discrimination, there's been a few false starts, but I hope that we'll be able to get that done.
All right. Well, a hearty thank you to the panelists today. I hope you enjoyed the conversation, and we're now ready for the next panel. Thank you.